We're back at the AKG Media Studio on the Selling Logan podcast. Today's guest, we have Brian Fang from S&B Legal. Welcome, Brian.
Thanks, Corey. Happy to be here.
Thanks, Brian. Well, I just want to get into things pretty much straight away. You are a conveyancer from Sydney. You do a lot of work with us at AKG. How long have you been doing it now for?
So I've been working or partnering up with AKG and Ray White for the last 3.5 years.
Yep.
I guess a bit about myself. I am a solicitor based in Sydney doing
Yep.
conveyancing work across Australia, predominantly in Queensland, WA, New South Wales and Victoria.
Yeah.
And yeah, it's been a good 3.5 years so far.
Yeah.
Many more to come.
Awesome. Well, I have one question now. I want to ask this question because I know a lot of agents just want to know some of these. I'm going to ask you some pretty tough questions today, and I hope not tough, but I'm going to ask you a lot of questions that a lot of agents want to know. And the first one is, can you talk us through on settlement date what do you actually do on settlement date?
Yeah, absolutely. So the great thing about settlement today is that everything gets streamlined across Pexa. Pexa is an online platform that allows settlement to take place. Back in the day, you'd have everyone meet up physically, hand over checks, transfer paperwork, and look, sometimes you get stuck in traffic or...
They still do them though, don't they?
They do for some exceptions, but by and large, most transactions are compulsory via Pexa. So with the exception of some exemptions, everything has to be done online. Again, streamlines the process. What we do as solicitors and conveyancers is to coordinate with all parties. So generally in a workspace, you've got the buyer side, the selling side, and then the mortgages on either end. So it's pretty much just making sure that all the correct payments are going to the right people, getting authority from the clients to sign off, make sure all the parties are happy, and then tick a couple of boxes and off we go.
Yeah. Okay. So just with that, and I also want to know, a lot of agents out there want to know and there's obviously reasons why, but why is it do solicitors always wait until the very, very last 4:59 of the deadline to send correspondence through? Can you give us an answer as to why they do that? Because there are obviously reasons why they do that.
Yeah. So look, I think it's case by case.
Yeah.
It depends on what's happening with the situation, but obviously the deadlines under the contract are 5 o'clock. If we don't meet it, then you start losing rights. So you start losing rights under the contract for your client. As long as it's done before the 5 o'clock mark, then you have a reasonable excuse to say, hey, we actually submitted those correspondence. But sometimes they are just nominal issues, like I couldn't reach the client. Clients work 9 to 5. They don't get any breaks depending on what they do for work. So, for example, we've got a few clients that work fly in, fly out. So for 3 days at a time, we can't contact them whatsoever. And so more often than not, they respond to us at the dead of night, which is usually after hours. So yeah, we try to reserve our clients' rights by submitting everything as quickly as we can. But sometimes that just so happens to be at 4:59.
One of the good things that I like about S&B Legal is you're very versatile in the fact that you can do pretty much nearly every state in Queensland, pretty much. Is that right? You just do New South Wales, Queensland...
Yeah, so we do pretty much every state in Australia. The only things that we don't really touch are the territories. So ACT, Tasmania, and Northern Territories are areas that we haven't yet explored, but not to say that we won't in the future. But yeah, like we specialize with helping investors as well. Yeah. And part of the good thing is we can help them understand the differences in the legalities in each state and walk them through the differences.
Okay. I just want to touch on how you said you help a lot of investors. Would you have any advice for some investors that think they could save a quick buck and just self-act?
So look,
because there's a lot of them out there that are very, very smart and probably can self-act, but I've had so many instances where it's probably not in their best interest to do it. Would you be able to explain why?
I wouldn't know why they want to do that. Sometimes people are just very emotionally attached and they want to do things themselves. Mm-hmm. Other times it's because they've lost trust in the people that they deal with. I find that second piece to be more true more often than not. But for myself, I purchase property, I invest as well, but I would never act personally, even though I'm a solicitor and I have my own firm. The reason for that is sometimes it can become a little bit too emotional. It can be impartial, a bit of bias as well. But for the average person, in either case, given that we now settle everything through Pexa, They would need a Pexa subscriber to help them finalize the last leg of the transaction.
So they need it anyway, don't they? Like,
yeah, exactly.
They've got to pay somebody. Yeah.
Yeah, so I understand that cost can sometimes be a bit of a factor, but when you actually look at and break down the fees involved, we're talking about $1,000 or $2,000 compared to a couple $100,000 purchase or sale that you're making, and it's kind of minuscule in the grand scheme of things.
Yeah. So we obviously got the little Christmas hats on today because we're coming up to Christmas. Another direct question: why can't we settle properties in between Christmas and New Year's? Like, is there something that we can just like? Why? Like, because that's a huge chunk. Like, there's settlement like pretty much from the 24th all the way through to like sometimes thirds. Some solicitor firms are shut until like the 10th of January sometimes.
Yeah.
And
it's equally frustrating for us. So if I can break that down a little bit, obviously we've got Christmas holiday and New Year periods.
Yeah.
Now, generally why we can't settle in this period is because banks are closed.
Yeah.
And for probably 90%, don't quote me on the percentages, of all transactions, in some way, shape or form, a bank will be involved, either from the selling side as a mortgagee or an incoming mortgagee for the buyer. So if they're not available to provide the funds or to provide you with numbers on how much to discharge the mortgage on, you can't really transfer the property. Now, the other thing is because banks are away, a lot of law firms take that time as the only time in the year that they can take some time off as well.
Yeah.
And most of them will take an additional week because the start of the year is quote unquote usually quiet in the real estate industry. But I think it's a very.
Do you think that'll change? Do you think it'll change soon? Like, surely a bank's got to go, look, there's a little bit of a market here if we, potentially open this up. Like, do you think that could change?
Potentially in the future, yeah, because again, we're talking about, it's not just that 2 week, but usually there's a bit of a crossover in the weeks to come after that, where deals are typically a little bit slower. Staff are just getting back from holidays. I think the organizations themselves would love to do that, but it's also a people issue. Like, we've got to build culture in communities and firms, so people will probably still take time off during that time.
Is there anything coming up, like with legislation changes and all these things? Is there anything coming up that will change? Like, the reason why I ask this is just because in New South Wales, the solicitors, everything, prepare all the contracts. Is that right?
Correct.
Where in Queensland, we don't do that. The agents, agents do that. Do you think we will follow that soon in Queensland? Do you think that the solicitors they'll make that happen soon?
Look, I've definitely heard conversations between people, nothing concrete that I can feel, but that's because solicitors will always think that they're going to be the best person to deal with those types of matters, and real estate agents will feel like they're in the best position to deal with them because it can be done in a more timely manner. But that to say...
What's the turnaround? Like, can you, like, for if I'm a seller in Sydney at the moment, what do I need? I need to prepare I need to pay a solicitor for a contract, and isn't there a few other forms that they need to do?
Yeah, absolutely. So,
can you talk us through what? Yeah,
of course. Yeah. So New South Wales and Queensland are very different when it comes to the actual contract itself. In New South Wales, the standard contract is about 30 pages. That's just the general terms and conditions.
Yeah.
Plus, the majority of all solicitors will have their own set of special conditions, which can range from 5 to 15 pages. And on top of that, the law prescribes that you must have certain documents attached to the back of that contract to make it valid. If for whatever reason you forget to attach one or it's just missing, it gives the buyers a right to rescind the contract and walk away with kind of no issues. Yeah. Which is not unheard of in Queensland because they've got other conditions here that allow buyers to do something similar. Yeah. But if you look at a typical Queensland contract, we're looking at 15 pages, including the general terms and conditions. There's no obligation to provide a title search, registered plans, sewer diagrams, council certificates. All that burden lies with the buyer, which is not necessarily a bad thing because they go and do their own investigations, make sure that they're fully happy with the property before they purchase. So the question you asked was, do we see the, signing process or creation of contracts changing? I don't necessarily think so, but that's because I'm not just looking at Queensland versus New South Wales. Across the board, I believe in WA and in South Australia as well, parts of the contracts are kind of drafted by the agents as well. But there are, like Victoria and parts of South Australia, solicitors are drafting it. So there's no right or wrong answer there. It's just the way the market has worked. And if it doesn't, if it's not broken, why change it?
Yeah, and I think if it does happen, I think it potentially will be a good change, similar to the other one that's when did it come in? I think it came in the 6.2 clause.
I think it was January
20.
2022.
Yeah, that obviously was a very very common sense one for that to happen. How it didn't happen sooner, I have no idea. But did you want to give us a definition of what that was and what it previously was and what was happening?
Yeah,
because that was pretty crazy. What was happening? It made headlines and everything, didn't it?
Yeah, absolutely.
Yeah.
So prior to the new edition of the contracts,
Yeah.
if for whatever reason settlement was to fall through and it was late, the sellers basically had a unilateral right to terminate on the buyer, clip the deposit and sell it to someone else.
Yeah.
Where this made headlines was, I think it was just a little bit after COVID, a lot of first home buyers got caught out, not because it was their fault, but sometimes it's because it's a bank or even their own solicitors. I think I touched on it before with paper settlements in particular, where you've got a designated meeting place and you just are running late, things outside your control. It effectively gave one party a unilateral right to be taking deposits. Now
That's crazy, isn't it? Like that's I find that so insane. Like just and I seen the news headlines when it hit these first home buyers. They saved up all their money to then have there was a day or two overlap with it, and the owners were quite within their right to take it, and some of them did. And the worst part is it wasn't the buyer's fault.
Correct.
That's the most heartbreaking part. So.
Yeah. So I think the one that comes to memory was it was a young couple. They made headlines because they lost the $70,000 deposit, which usually will take the average person at least 5 or 6 years. Average couple like 5 or 6 years to save up. So overnight, they basically lost 6 years worth of hard work, and it was not through any fault of their own. It was because their bank showed up 15 minutes late. I think luckily for them in that scenario, the bank did end up compensating and repaying them that deposit. However, you got to factor in everything else. They've lost the home that they really wanted to buy. They had time spent on the market where they could have spent looking for other properties. And as we all know, Australia is a very property-focused country. Time is money. As soon as you miss that boat, it just keeps going up. Yeah. So opportunity cost is a massive thing as well. Yeah. So the introduction of 6.2 has been, I think, a very good thing because it allows for a little bit of a buffer, not so much where either side will be significantly penalised by anything, but it gives them a bit more time to prepare everything in case there is an emergency. But by and large, most settlements will take place on time, especially now that we do have Pexa as well. Yeah. It's quite efficient.
Yeah. So you just said buying large. Now, you do a lot of transactions all over the country. I'm just going to be blunt. What's the biggest one you've settled? Give me a figure. What's the biggest property settlement you've done?
So the biggest one that I've done personally was a $50 million hotel transaction in New South Wales. It was a commercial one. It was also
50 mil.
It was 50 million. I think it was 45 plus GST. Yeah, 45 plus GST. So just on
sorry, forgot the GST component.
Yeah, because
just an extra 5 mil.
4.5 million there. It was quite insane. But that deal was something that would have been unheard of, simply because it was a 30-day transaction with no DD. Effectively, contracts were signed. The buyer didn't have any financing and just purchased it outright.
But cash?
Cash. Usually,
just Adrian Patelli just...
It wasn't Adrian.
It wasn't Adrian?
No, it was, I think, some overseas hedge fund. They were just acquiring a whole bunch of properties right after COVID. But in my previous life, when I worked in corporates, I think the largest transaction we did was 200 million. But those are for big conglomerates.
How do you go, the pressure of that, not f***ing that up? That's huge pressure because
that $200 million deal, obviously I worked at a sizable, reputable mid-tier firm, and number one, we've got insurance. Yeah. Okay. Number two, we've got a big team around us that help support and review documents. So it's not just one set of eyes, it's multiple sets. Yeah. Just so you don't make those mistakes and have to claim on insurance. But as a fail-safe, we always have insurance as well.
Always, you always got to...
But thankfully, that was a very... all those transactions have actually been quite smooth and sometimes actually better than residential because the purchasers and the sellers there are a little bit more commercially minded. They know exactly what they're doing and they're not as emotionally biased.
Now, one other question that I know a lot of agents would love to know the answer, because this has happened to me personally so many times. Is there a reason why, like, I know you don't, you always include me in the correspondence, but is there a reason why they don't include agents in the correspondence? Is it just they don't have to, so they don't do it, or is it just laziness, or is there a reason why?
I don't think there is a specific reason why. Usually, even for us, from the get-go, I always ask our clients for consent to make sure that if they want us to keep anyone in the loop, to make sure that there's effective and timely communications to give us authority so that we can make sure that everyone is kept in the loop. Sometimes people either forget or they're just focused on the single task at hand, and it's just a forgotten task that they've done.
Do you think that'll change soon, where they have to? Because I've literally had buyers rock up at our office, and I'm out, doing real estate things. Buyers rock up, they've paid for a new home, they're so excited, and they come in, try to collect keys, and the solicitors didn't even tell me that the settlement was brought forward 3 days, and then we just look so silly.
Yeah.
Like, do you think that'll change soon, like where they have to include some sort of correspondence?
I'd hope so, because
I know that's a tough question, but
it is, because it's something across the industry.
Yeah.
I've often had times where clients would call me after settlement saying, "Hey, I'm ready to go collect my keys," but the agent said that I can't get them yet. Why is that? And I have to explain to them that, look, in order for keys to be released, both sides of the transaction has to confirm that it has gone through, so that obviously keys just won't be handed over willy-nilly.
Yeah.
Ideally, we keep agents and sometimes even brokers in the loop, because the other people that often get left out of the transaction is brokers. They see one end of their portal to say, yep, we've got finance ready to go, but they don't actually know when settlement is. But just for everyone's sake, if everyone is informed, it just makes the whole process a lot smoother.
Yeah. So you prepare contracts in Sydney. Is there any particular clauses or any recommendations that you'd maybe recommend to buyers to try and put in the contracts to protect themselves? Obviously, the main ones are, building and pest inspections, finances. Is there anything else that you'd recommend maybe putting in?
Funnily enough, there is no building and pest or finance conditions in New South Wales. So those terms are actually...
Sorry, what? Say that again?
Yeah,
there's no building and pest
There's
clause.
no building and pest or finance clause. In actual fact, New South Wales, we have those set of special conditions that I mentioned earlier. Most of the time, solicitors will include a clause there that says, hey, you're pre-approved, or you warrant that you've got finance, you're not going to back out because of financial reasons. That's already in the contract. So there's no way out for a buyer if for whatever reason finance falls through. That's 10% gone straight away.
So is that true that in New South Wales, if they make an offer and they sign a contract and they put 10% in, and they can't for whatever reason get finance, they lose that deposit? Is that correct?
That's correct. So even if they don't put down a 10% deposit, so sometimes for cash flow purposes, we help clients negotiate a 5% down payment.
Yeah.
If halfway through the transaction they end up not being able to complete, they will be liable for the full 10%.
Does that happen often?
Hopefully not.
Has it happened to you?
No.
No? Okay. Sorry. You haven't had to do that one yet?
No,
Yeah.
thankfully not.
Yeah.
But the other thing is, we do have a 5-day cooling off period, which people rely on a lot more often. And sometimes, just like in Queensland, if we need to extend it, we get it by consent from the other side.
Yeah.
But if you do cool off, you do lose, I think it's 0.25% anyway, but nominal in the grand scheme of things. For Sydney properties,
cheaper though.
minimum like 1.5, wherever you are. So, very scary because we don't have those protections there. But that's why it's very important in Sydney, or even New South Wales in general, before you sign a contract, the contract should be reviewed by a solicitor.
Yeah.
So that's not something that is always done in Queensland, even though it's also recommended. Yeah. But at the same time, the main thing that people fall through on purchasing a property is usually on finance, because once you've sighted the property, you fall in love with it. Yeah. The only other reason why you wouldn't go ahead is if you don't have the money for it.
Yeah.
Aside from building and pest issues. So in the lead up to auctions in Sydney, in the lead up to signing contracts, we also recommend that clients go and get their building inspections done.
Yeah.
Generally speaking, vendors wouldn't oppose that, but you fork out your own money, you use your own report,
similar up here.
and basically you use that as your frame of reference for how much you would like to offer on the property. The other thing would be strata inspection reports, which is more common in Sydney. We've got a lot of high rises. I'm not sure if you're familiar, but we had Opal Towers, Mascot Towers, a lot of issues over the last couple of years where there was either a mismanagement of funds or there was just building issues that could have been prevented. That resulted in basically all the homeowners having to fork out extra $20,000, $30,000, $40,000 just to fix these problems. So very important to get the contracts reviewed and any other documents on the side as well.
Yeah. Okay. Well, I do appreciate your time today, mate. I did have to ask you a lot of questions that a lot of agents generally just wanted to know. So we do appreciate that you were able to answer them.
Happy to help.
All right. Thanks very much for that, Brian.
Thanks, Corey.